All rise. The bailiff's voice carried through Federal Courtroom 24 as Judge Richard Lane entered with a stormy expression, known across legal circles as the hammer for his fierce questioning and zero patience for unprepared lawyers. Lane had the power to end a career with a single comment. Today he seemed even more impatient than usual. The Wilson voting rights case, he announced sharply, glaring at the crowded courtroom. Let's not waste time. The state's attorney stood up confidently, expecting an easy victory. After all, the government almost never lost these types of cases. Then, Jasmine Crockett rose from her seat. Few expected much from her. At only 38, she was facing a legendary federal judge in her first major case. Most observers believe she didn't stand a chance, not against the state, not against the odds stacked against her and the thousands of minority voters she represented. Crockett approached the podium carrying just a single manila folder. No team of paralegals, no piles of legal documents, only that one folder. The opposing counsel smirked as if the outcome was already decided. Judge Leon's eyes narrowed. Then Crockett spoke her first words. The entire courtroom fell silent. The judge's face shifted instantly. His eyes locked on her as if she had just revealed something no one expected. The state's attorney stopped smiling. The gallery whispered in disbelief. Your Honor, Crockett said firmly, pulling a paper from her folder. Before I proceed, I'd like to present evidence that will completely change what we understand about this case. What she revealed would not only shake that courtroom, could redefine voting rights law across the United States for years to come. If you want to know what was in that file and how it left the Hummer speechless, make sure to hit that like button and subscribe, because what happened next stunned everyone. The Wilson versus State Election Board case began after new voter ID laws blocked nearly 200,000 citizens from casting their ballots in the previous election. On paper, these rules looked neutral, requiring a government-issued photo ID to something that seemed reasonable to most Americans. But in targeted communities, DMV offices have been shut down, hours slashed, or moved far from public transport routes. For many residents, obtaining an ID now meant losing a day's pay, finding child care, and traveling over 40 mi each way. The results were devastating. In Westwood County, voter turnout fell by 63% after the law took effect. In predominantly minority neighborhoods like Eastern Heights, polling places reported hundreds of longtime voters turned away. Elderly citizens who had voted faithfully for decades were suddenly told their old IDs were invalid. Voted in every election since 1964, said 78-year-old veteran James Wilson standing outside the courthouse. I fought for this country, paid taxes my whole life, and now they say my VA card doesn't count. That's not right. Wilson became the lead plaintiff after walking 3 miles to vote, only to be denied his ballot. Judge Richard Lane was not an ordinary federal judge. At 72, he commanded both respect and fear in the legal world. Appointed by President George W. Bush in 2002, he built a reputation as fiercely independent and unpredictable. He once ruled against the NSA's phone surveillance program, calling it almost Orwellian, yet had upheld other controversial policies. Lawyers who entered his courtroom studied his previous rulings obsessively, knowing he didn't follow party lines, only strict legal reasoning. Law clerks nicknamed him the Hammer for how he destroyed weak arguments. If you walk into Judge Lane's courtroom unprepared, one attorney warned, you might as well surrender the case. His unmatched recall of case law made bluffing impossible. Many attorneys had been publicly embarrassed for trying. Across from him stood Jasmine Crockett, a woman whose journey to that moment was anything but ordinary. Raised in South Detroit by a single mother who worked for the Postal Service, Crockett had hustled through school and law by working late-night jobs. Unlike the polished lawyers who usually appeared in federal courts, she had built her career defending people who couldn't afford expensive representation. Before this voting rights fight, she was known for winning cases that freed innocent people wrongfully convicted of crimes. In one landmark case, she uncovered hidden police misconduct buried deep in thousands of files, proving a man's innocence after 12 lost years. What made this case so extraordinary wasn't just the legal stakes. It was the David versus Goliath battle unfolding in real time. The state had a 6-member legal team from one of Washington's most elite firms, boasting over a century of combined courtroom experience. Their lead attorney, Bradley Thompson, had argued before the Supreme Court 7 times and never lost a voting rights case. His team submitted a 378-page legal brief tearing apart Crockett's arguments from every possible angle. Crockett's own filing was just 42 pages long. What no one in that courtroom realized was that Jasmine Crockett's strategy was unlike anything seen before. While most civil rights attorneys leaned on sweeping constitutional arguments and emotional appeals, she had spent 6 painstaking months building her case from the ground up, using a completely different approach that would soon leave The entire courtroom stunned Judge. She had personally traveled to every community affected by the new law, gathering 358 first stories from voters who had been denied the chance to cast their ballots. Using census data, she compared those accounts with maps of DMV locations, building a detailed picture of how the regulations disproportionately harmed certain districts. But her most powerful evidence came from thousands of internal emails she obtained through Freedom of Information Act requests. For nearly 3 weeks straight, Jasmine Crockett worked 18-hour days inside her small office, manually reviewing over 11,800 government documents. Deep within those files, she uncovered something no one, not even the state's attorneys, knew existed. That morning, the courtroom was overflowing. Civil rights leaders sat beside ordinary citizens whose right to vote hung in the balance. The press section was packed with national media outlets, all sensing that this case could become a landmark moment for voting rights laws in 17 other states. As Judge Richard Lean entered and called the session to order, not a single person in the room could have imagined they were about to witness one of the most intense and historic legal battles in recent memory. This was more than just another hearing. It was a fight that could redefine how American courts interpret voter access and equality for generations. Have you ever experienced challenges while trying to vote? Were polling places easy to reach in your community? Or did you face long lines, confusing rules, or limited access? Share your story in the comments below. Real stories from real voters help reveal how deeply these laws affect everyday Americans. The air inside the courtroom felt electric as the bailiff called for order once again. All rise. The United States District Court for the District of Columbia is now in session. The Honorable Judge Richard Leon presiding. The judge stepped in, his black robe flowing behind him, eyes sharp as he scanned the crowded room. "You may be seated," he said in a deep, commanding tone. "We are here today to hear oral arguments in Freedom Access Project versus Brennan Election Commission. Miss Crockett, you may proceed." Jasmine Crockett walked to the podium with calm confidence. The echo of her heels against the marble floor was the only sound. She placed a single binder in front of her, but barely touched it. "Thank you, Your Honor," she began, her voice steady and composed. This case asks a fundamental question. Can a state enforce voting regulations that appear neutral on paper, but have clearly discriminatory effects in practice? The Supreme Court has long recognized that the right to vote is the foundation of every other right. When that right is weakened, our entire democracy suffers. She paused, meeting Judge Lean's gaze. He leaned forward, listening intently. "The state claims these ID laws prevent voter fraud," she continued. "Yet, in the 10 years before these rules took effect, there were only 7 proven cases of in-person voter fraud out of more than 14 million votes cast. That's a fraud rate of just 0.05%. Judge Lean interjected, as was his habit. "Miss Crockett, fraud prevention remains a valid state interest regardless of how rare the instances may be." The Supreme Court affirmed this in Crawford v. Marion County. This was the point where many lawyers would grow defensive or retreat. Crockett did neither. "You're absolutely right, Your Honor," she said confidently, catching him off guard. Crawford did affirm fraud prevention as a legitimate state concern. That same case also introduced a balancing test weighing the state's interest against the burden imposed on voters. With that, she reached for a folded map. "With the court's permission, I'd like to show you something," she said. The judge nodded. Crockett unfolded a large color-coded map displaying the entire state. "The red areas," she explained, "represent communities where more than 30% of eligible voters lack the required photo ID. The blue dots mark DMV offices where those IDs can be obtained. Notice in the deepest red zones there are almost no blue dots." Judge Leon studied the map closely, his brow furrowed. "And your point, counselor?" "My point, Your Honor," she said, "that for voters in these red areas, mostly minority communities, getting an ID means traveling up to 175 a round trip. For many without vehicles, that's a 3-hour bus ride each way if bus service even exists. The few DMV offices serving these regions are open only 2 days a week from 900 a.m. to 400 p.m., hours that make it nearly impossible for working people to go without losing pay." The state's attorney, Michael Reynolds, abruptly rose. "Objection, Your Honor. The inconvenience of travel doesn't rise to a constitutional violation." Judge Lean turned to him sharply. "This is not a trial, counselor. You'll have your turn. Sit down." Then, glanced back toward Crockett, he said firmly, "Please continue." Crockett gave a respectful nod and pressed forward, her calm presence commanding the full attention of the courtroom. "Thank you, Your Honor." Jasmine began, her tone steady but firm. "In Harper v. Virginia Board of Elections, the Supreme Court ruled that no state may impose any cost, direct or indirect, on the right to vote. While the state may not be charging a fee for the ID itself, our economic analysis shows that the real cost, including lost wages, transportation, and obtaining required documents such as birth certificates, averages about $175 per voter. She continued to build her argument slowly and deliberately, layering each point like bricks in a wall. Every potential counterargument was anticipated and addressed before Judge Leon could even voice it. For nearly 40 minutes, Crockett moved through intricate areas of constitutional law, referencing landmark precedents that spanned several decades of voting rights cases. Judge Leon, known for his quick interruptions and relentless hypotheticals, found himself listening more than speaking. When he did interject, his questions were met with precise, unflinching answers that reflected not only preparation but mastery. The courtroom sensed it. Something extraordinary was unfolding. Then came the question that would shift the entire momentum of the case. The judge leaned forward. "Miss Crockett," he said, "let's assume a hypothetical scenario. Suppose the state assigns polling stations based on the last 4 digits of each citizen's social security number. Now, if this system on its face seems neutral, ends up forcing minority voters to travel twice as far as others with no evidence of intent to discriminate, would that violate the Constitution?" The room went silent. It was exactly the kind of complex hypothetical that had trapped many lawyers in his courtroom before. Crockett paused for a moment, gathering her thoughts. "Your Honor," she replied calmly, "that situation mirrors the logic of Jillian v. Lightfoot. In that case, a city redrew its boundaries in a way that excluded 99% of black voters without mentioning race in the statute. The court still struck it down, recognizing that a law can appear neutral yet produce a discriminatory outcome. She took a breath, then pivoted unexpectedly. "And Your Honor, your hypothetical actually highlights something critical about this case. The state is effectively arguing that as long as race isn't mentioned directly, any level of disparate impact is permissible. That logic is fundamentally at odds with both precedent and principle." Then she surprised everyone. "May I approach the bench again?" she asked. Judge Lean, visibly intrigued, nodded. Crockett retrieved a printed email chain from her table and handed copies to both the judge and opposing counsel. "This," she said, "is an internal communication between the state's election commissioner and the consultant who drafted these ID rules. Please look at page 3. Courtroom buzzed as the judge began reading. "The beauty of using these specific criteria," the consultant had written, "is that they disproportionately affect demographic group A while allowing us full deniability since race is never mentioned explicitly." A ripple of shock spread through the gallery. Judge Leon's eyebrows rose slightly. "And how did you obtain this document, Miss Crockett?" he asked. "Through standard discovery procedures, Your Honor," she replied. "It was among the 50,000 documents turned over by the state. I doubt they realized it was there. It was buried deep in a section labeled Database Technical Appendices across the aisle." The state's attorney, Michael Reynolds, flipped through his copy frantically, his expression draining of color as he located the damning sentence. "This case," Crockett continued, "isn't only about disparate impact. It's about intentional discrimination disguised as neutrality. The Supreme Court's Arlington Heights framework exists precisely to expose this kind of hidden bias." The atmosphere in the courtroom changed entirely. What had begun as a routine constitutional hearing now felt like a moment of history unfolding in real time. The spectators leaned forward. Even the clerk seemed transfixed. Judge Lean read the email again, slower this time, his face tightening in thought. For a long moment, the only sound was the quiet hum of the air conditioning. Finally, he looked up, his tone more measured. "Miss Crockett," he said, "you've presented substantial evidence of intent, but even assuming discriminatory purpose, the state argues that its regulations still survive strict scrutiny because preventing voter fraud is a compelling governmental interest." The tension in the room deepened. This was the final test of her argument. Every eye was on Jasmine Crockett as she stood silent for a beat, then began her reply with quiet authority. "Your Honor, for any law to withstand strict scrutiny, it must be narrowly tailored to serve a compelling interest. These ID laws fail that test for 3 clear reasons." She lifted one finger. "First, they are not narrowly tailored. Our analysis shows that 94% of the burden falls on minority communities to solve a problem in-person voter fraud that statistically does not exist." A second finger. "Second, there are at least 16 less restrictive alternatives that could achieve the same anti-fraud purpose without disenfranchising lawful voters. Those alternatives are detailed in our brief." A third finger. "And finally, the newly uncovered email proves that fraud prevention was never the real motivation. When the justification is pretextual, strict scrutiny cannot be satisfied." Then came the moment that would dominate headlines for weeks. Your Honor, she said with the court's permission, I'd like to present one final piece of evidence obtained only yesterday. Judge Lean gave a slow nod. Crockett handed a sealed envelope to the clerk who brought it to the bench. As the judge opened it, his face shifted curiosity, giving way to disbelief. Inside was a confidential memorandum from the state's own election security division dated just 2 weeks before the new ID law was announced. The report stated plainly, after a comprehensive review, we find no evidence that in-person voter impersonation presents any meaningful threat to election integrity. A collective gasp spread through the courtroom. Even Judge Lean's expression softened from stoic neutrality to visible astonishment. Resources should be focused on fixing the real weaknesses in the election system, especially in cybersecurity. Judge Leon lifted his head, eyes widening. This completely undermines the state's main claim about why these regulations exist. Yes, Your Honor, Crockett replied confidently. The commission ignored its own security team's report because the real goal behind these regulations was never preventing fraud. The state's attorney, Michael Reynolds, quickly stood. Your Honor, we've never seen this document before. We object to its late submission. Judge Land gave him a sharp look. Mr. Reynolds, this appears to be your client's own internal memorandum. Are you suggesting the commission withheld this during discovery? Reynolds hesitated. I'd need to check with my client. Suggest you do that immediately, the judge said coldly. This court takes discovery obligations extremely seriously. Turning back to Crockett, Judge Lean examined her closely. The room was silent. Everyone could sense something rare was unfolding. Known for his emotionless expression, Judge Leah now seemed deeply moved. Miss Crockett, he said, his voice echoing through the courtroom. In my 30 years on this bench, I've never seen reasoning of this level. You've just reshaped how this entire case must be viewed. The statement sent ripples through the courtroom. Legal analysts would later say they had never heard Judge Lean offer such open praise during a hearing. Yet, what happened next was even more powerful. Instead of soaking in the compliment, Crockett responded calmly, "Thank you, Your Honor. But this case isn't about legal brilliance or individual performance. It's about the constitutional right of every American to vote freely, without man-made barriers designed to suppress their voices. The 150,000 citizens who've effectively lost that right deserve this court's protection far more than I deserve any recognition." Her words instantly shifted focus from herself back to the larger principle at stake. Several spectators nodded quietly in agreement. Judge Lean leaned back, a small smile breaking across his face. "Well said, Counselor. Well said indeed." He turned to the state's attorney. "Mr. Reynolds, it appears you have some serious work ahead. Proceed." Reynolds walked to the podium, clearly shaken. His earlier confidence was gone as he fumbled through his notes. "Your Honor, while Miss Crockett's remarks were indeed impressive, she misrepresents the state's position and the relevant law," but his argument faltered. Judge Leon interrupted repeatedly with sharp questions. "Mr. Reynolds, how do you defend your fraud prevention claim when your own security team concluded in-person fraud is virtually non-existent? How do you explain the internal email discussing how to target particular demographic groups using neutral criteria? And with only 0.05% of votes showing any sign of fraud, how can this regulation, which affects 70% of eligible voters, be considered narrowly tailored?" Reynolds struggled to respond. By the time he finished, the outcome seemed clear to everyone in the courtroom. When Crockett stood for her brief rebuttal, her quiet but steady tone filled the chamber. "Your Honor, this case isn't about complex legal theories. It's about whether the Constitution allows a government to make voting harder for some than for others. The evidence and proceeding make the answer plain. It does not." As she gathered her files and sat down, the courtroom remained silent. Everyone knew they had witnessed something historic, not just outstanding advocacy, but a defining moment in the fight for voting rights when Jasmine Crockett exited the courthouse. She was surrounded by cameras and reporters eager for her response. "Miss Crockett CNN, what's your reaction to Judge Lean's remarkable compliment?" one asked. She paused thoughtfully. "What matters isn't praise for me. What matters is whether the court defends the rights of voters silenced by these unfair rules. This case has always been about them." Her answer quickly went viral, earning praise for keeping the focus on justice rather than personal credit. Behind closed doors, the state's legal team scrambled. Reports soon surfaced that emergency meetings were underway to discuss a possible settlement before Judge Leon could issue a likely devastating ruling. Legal experts across party lines agreed what happened in that courtroom had changed everything. Harvard law professor Lawrence Tribe shared his reaction on social media. What Jasmine Crockett accomplished today wasn't just skilled advocacy. It was a masterclass in constitutional law that future generations of lawyers will study. Even prominent conservative scholars couldn't deny the power of her performance. Former Solicitor General Paul Clement remarked on a legal podcast, "No matter your political stance, the level of advocacy Ms. Crockett displayed was extraordinary. She broke down the state's position piece by piece using precedent and evidence with surgical precision." 3 weeks later, Judge Leon released his ruling, a detailed 87-page opinion granting a preliminary injunction that stopped the controversial voting regulations from taking effect. His opening lines were unusually direct. "This case is a textbook example of regulations that, though neutral on paper, were intentionally designed to restrict the voting rights of minority citizens. The evidence of discriminatory intent is overwhelming, and the state's justifications cannot survive constitutional review." Judge Leon's decision reshaped how courts evaluate election laws that disproportionately affect minority communities. He wrote that when voting rules place heavier burdens on certain groups, judges must look beyond official explanations. Internal communications, data showing unequal impact or contradictions between public statements and internal reports can reveal unconstitutional intent. Even without any explicitly racial wording, the decision sent shockwaves through legislatures nationwide. Within days, 5 states announced plans to re-evaluate similar laws. Voting rights organizations across more than a dozen states filed new challenges, citing Judge Leon's opinion as persuasive authority. For thousands of voters, the effects were immediate. The state was ordered to halt its strict ID rules and create a fairer system, ensuring equal access to the polls. In the next election, turnout in previously restricted areas surged by 31%. 2 months later, Jasmine Crockett was invited to deliver the keynote address at the American Bar Association's annual Civil Rights Conference. Her speech, titled "Constitutional Advocacy in the Modern Era," became required viewing in law schools across the nation. "The Constitution's promises don't fulfill themselves," she told the packed hall. "They depend on advocates willing to connect abstract principles with real lives. When we let technicalities outweigh fundamental rights, we betray the very document we claim to honor." Her closing message would be quoted by future generations of attorneys. "The strongest weapon in constitutional advocacy isn't eloquence or ideology, it's preparation. The quiet, disciplined work of mastering facts, understanding precedent, and anticipating every counterargument before stepping into court. That work happens long before the cameras roll. But when the moment arrives to defend someone's rights, that preparation becomes true power." Perhaps the most meaningful praise came from Judge Leon himself. In a rare post-decision interview with Legal Times, he reflected, "Judges are supposed to be guided by law and facts alone. Sometimes an advocate presents them with such clarity that it deepens your understanding of the Constitution itself." Ms. Crockett's case was one of those moments. The ruling's greatest impact was not in Washington, but in communities nationwide. In the years after Judge Leon's opinion, states were forced to revisit voting procedures that had unfairly hindered minority, elderly, and disabled voters. Access to the ballot expanded. Participation rose. Democracy became more inclusive. Law professors now teach Crockett's case alongside landmark voting rights precedents and constitutional law textbooks, include excerpts from her oral arguments and Judge's ruling. A new generation of young lawyers studies Crockett's technique, her precision, calmness, and command of both law and principle. For Jasmine Crockett, the case became both a defining milestone and a springboard for greater influence. She continued championing civil rights, focusing on voting access, criminal justice reform, economic fairness. Yet, she never lost touch with the communities she represented. When a journalist later asked if she saw herself as a legal celebrity, Crockett smiled. She said, "I see myself as someone doing the work that must be done. Millions of Americans still face barriers to their rights. My job is to use whatever skill I have to protect them." The lesson from that unforgettable courtroom day was never about fame or applause. It was about the quiet strength of preparation, the courage of moral conviction, and the power of principle in action. One person armed with knowledge and purpose can still reshape the law and history itself. For those who watched that moment unfold, the memory remains etched in time. A silent courtroom, a brilliant advocate, a moved judge, and the Constitution defended with grace and determination. For the thousands whose right to vote was restored, impact endures the simple, powerful ability to stand as equal participants in American democracy. If this story of courage and advocacy inspired you, don't forget to like this video and subscribe to our channel. We bring you powerful courtroom moments that are transforming the fight for justice and protecting the future of constitutional rights. Share this story with anyone who believes preparation and principles still matter in the pursuit of truth.